Ah, much love and respect. Pura vida, mi gente. Thanks for tuning in once again. This is part 3 of the Washitaw Muurs series. Today we're going to be continuing and talking about the court cases that were brought up due to this land grant. What was decided? Did they really win? Did they lose? Was it in a district court? Was it in the Supreme Court? What years was it? What stipulations were in the contract? What did the Chief Justice and the Supreme Court decide? And why? So we're going to be reading a couple of articles and books on these legal disputes for these lands of Louisiana, and culminating to the Louisiana Purchase and the treaties with the United States, how this caused a lot of disputes, especially if things weren't stipulated or recorded correctly, imperfect as they called it. Let's see what we can find historically regarding these cases. This will include the United States versus Turner court case, which a lot of people always try to send me, now especially when I started doing this series. Okay, so again, before I continue, just want to say that again, this is not impersonal. A lot of people getting upset, attacking me, saying I have an agenda and all this stuff, and disrespecting people. And again, I just approach all my presentations the same way. This ain't personal. And again, try to reach out to people who may have known the family so they can be involved. And again, we're trying to break out of these old doctrines, so don't take that personal. We're always learning. You got to empty your cup, especially if we're just holding information in that we gained in the 90s and 80s, right? So I hope you guys enjoyed this part. We're going to do a lot of reading, so I hope you're ready. Yeah, it's one of those. Do a lot of reading. Hope you guys enjoy it. Much love. I'm going to read from this book. It's The Biographical and Pictorial History of Arkansas by John Hallam. This is volume 1. This is from 1887. And we go to page 23 of this book. And right here, it begins talking about Grand Maison's claim on the Washita. We, Francis Louis Hector, Baron de Carondelet, Knight of Malta, Brigadier General of the Royal Armies of His Catholic Majesty, Military and Civil Governor of the provinces of Louisiana and West Florida, Don Francis Rendon, Intendant of the Army and Deputy Superintendent of the Royal Domains in the said provinces, Don Joseph de Orue, Knight of the Royal and Distinguished Order of Charles III, Principal Accountant for the Royal Chest of this Army, exercising the functions of Fiscal of the Royal Domains, declare that we agree in contract with the Señor Marquis de Maison Rouge, an immigrant French knight, who has arrived in this capital from the United States, to propose to us to bring into these provinces 30 families who are also immigrants. All right, so again, as we got in part 2, Marquis de Maison Rouge contract and land grant was so France can colonize this part of USA with other European immigrants in order to descend the Ohio for the purpose of forming an establishment with them on lands bordering the Washita, designed principally for the culture of wheat and the erection of mills for the manufacture of flour under the following conditions. First, we offer in the name of His Catholic Majesty, whom God preserve, to pay out of the royal treasury $200 to every family composed of 2 white persons fit for agriculture. All right, so dodge the hijack. Remember when they say white in these times. Or for the arts useful and necessary for the establishment as house or ship carpenters, blacksmiths, and locksmiths, and 400 to those having 4 laborers. And in the same way, 100 to those having no more than 1 useful laborer or artificer, as before described with his family. Second, at the same time, we promise, under the auspices of our sovereign monarch, to assist them forward from New Madrid to Washita with a skillful guide and the provisions necessary for them till their arrival at their place of destination. Third, the expenses in transporting their baggage and implements of labor which shall come by sea to this capital shall be paid on account of the royal domains, and they shall be taken on the same account from this place to Washita, provided the weight shall not exceed 3,000 pounds for each family. Fourth, there shall be granted to every family containing 2 white persons fit for agriculture 10 arpents of land, extending back 40 arpents and increasing in the same proportion, to those which contain a greater number of white cultivators. Again, that's the hijack with the white. Remember what free whites meant. Fifth, lastly, it shall be permitted to the families to bring or cause to come with them European servants, who shall bind indentured to their service 6 or more years, under the express condition that if they have families, they shall have a right, after their term of service is expired, to receive grants of land proportioned in the same manner to their numbers. So again, we've gone over this in my indentured servant videos, how after they will be freed, get their freedom dues, get their land and everything, after their 7 years of service, they can also do the same thing and bring their families, have them work, other people, other indentured servants, and be their own plantation masters, right? As they call them today. Thus we promise, as we have here stated, and that it may be come to the knowledge of those families which propose to transport themselves hither, we sign the present contract with the aforesaid Señor Marquis de Maison Rouge, to whom that it may be made plain a careful copy, shall be furnished. New Orleans, 17th of March, 1795. The Baron de Carondelet, Francis Rendon, Joseph de Orue, the Marquis de Maison Rouge, having laid before the King what you have made known in your letter of the 25th of April last, number 44, relative to the contract entered with the Marquis de Maison Rouge for the establishment of the Washita, of the 30 families of farmers, 30 families that were bringing from Europe, of farmers destined to cultivate wheat for the supply of those provinces. His Majesty, considering the advantages which it promises compared with the preceding, has been pleased to approve it in all its parts. By his royal direction, I communicate it to you for your information. God preserve you many years. Madrid, 14th of July, 1795. Gardoki. To the Intendant of Louisiana, New Orleans, November 13, 1795. To be transmitted to the Principal Office of Accounts, Contaduría, of the Army and Royal Domains, for their information, and 2 certified copies to be provided for this Secretary's office. Rendon. Don Gilbert Leonard, Treasurer of the Army, exercising the functions of Royal Accountant, and Don Manuel Gonzalez Admides, exercising those of Treasurer per interim of the Royal Chest of this province of Louisiana. We certify that the 2 foregoing copies are conformable to the originals, which remain in the archives of the Ministry of the Royal Domains, under our charge that the contractor, the Marquis de Maison Rouge, complied punctually with the terms which he promised in said contract, and that this may be made manifest conformably to the order above inserted of this Intendancy General, we give the President in New Orleans the 5th of August, 1803. Gilbert Leonard Manuel Armiris. The Baron de Carondelet, Knight of the Order of St. John, Marshal de Camp of the Royal Armies, Governor General, Vice Patron of the provinces of Louisiana and West Florida, Inspector of Troops, etc., for as much as the Marquis de Maison Rouge is near completing the establishment of the Washita, which he was authorized to make for 30 families by the Royal Order of July 14, 1795, and desirous to remove for the future all doubt respecting their families or new colonists who may come to establish themselves, we destine and appropriate for the establishment of the aforesaid Marquis de Maison Rouge, by virtue of the powers granted to us by the King, the 30 superficial leagues marked in the plan annexed to the head of this instrument, which the limits and boundaries designated, with our approbation by the Surveyor General, Don Charles Lavaux Trudeau, under the terms and conditions stipulated and contracted for by the said Marquis de Maison Rouge, and that it may at all times stand good. We give the present signed with our hand, sealed with our seal at arms, and countersigned by the underwritten honorary commissary of war and secretary of His Majesty for this Commandancy General, New Orleans, the 20th of June, 1797. The Baron de Carondelet, Andrew Lopez Armesto. Note that in conformity to this contract, the Marquis de Maison Rouge is not to admit or establish any American in the lands included in this grant. All right, that was a big stipulation, but she didn't follow. And listen to what they were telling him. This French royal noble, right? This Knight of Malta, Catholic Vatican Roman soldiers, right? To not let any Americans, who's includes Americans? That's American Indians, right? Who's the original Americans? Copper-colored tribes of America. Also, the Sephardic Moorish people, Protestants, right, who had become Americans, citizens. The Baron de Carondelet. This grant for 30 leagues of land, Spanish measure, is equivalent to 133,165 English acres. The old French town of École-Fabre, now called Camden, on the Washitaw River. The county seat of Washita County is, I think, on this grant. This is one of the very few perfect grants ever made by either the kings of France or Spain, but the old Company of the Indies, established by John Law, whilst in Louisiana was owned and feed by the Lord Proprietors, granted a vast number of perfect grants. But few grantees of the king's domain in those early times ever proceeded further than presenting their petition, procuring a concession and a survey. These titles, although defective in not having the confirmatory sanction of the crown, passed by sale and inheritance, and were treated as perfect by the colonists and officials. These imperfect grants caused a vast volume of congressional legislation and litigation in state and federal courts, which lasted 75 years, and that includes the Maison Rouge. That's what they're saying. These imperfect grants. The Baron de Bastrop was the colonizer of Washita County. In June 1795, he contracted with the Spanish authorities to bring in 500 families to the Washita and its neighborhood. All right, remember, not Americans. He was bringing in Europeans, helping a lot of Catholics run away, people being persecuted from the Protestants, reversing roles. And he was using these people for especially cultivation of wheat, reserving to himself the right to export his flour to Havana, all right, Cuba, where it was not primarily needed in the provinces. And so rapidly did he proceed in the execution of his contract, the Baron de Carondelet the following year granted him 144 leagues of land, which is in around numbers 640,000 English acres. This grant included Bayou de l'Air and vicinity on the line between Louisiana and Arkansas, and embraces land in both states. The Governor General and Commissary of War, Armesto, in the body of the concession incorporated the following liberal terms. The government will charge itself with the conducting of the families from New Madrid to Wachita, and will give them such provisions as may appear sufficient support for 6 months, and proportionally for their seeds. They shall not be molested in matters of religion, but the apostolic Roman Catholic worship shall alone be publicly permitted. Catholics, these are Catholics. It must not be forgotten in connection with what I have said about the census taken under the order of Gayoso, Governor General in 1799, that the Washita country does not appear to be embraced in what was then called the Arkansas. Boundary lines were then very poorly defined. Often the inhabitants of a given locality did not know to what particular jurisdiction or geographical division they belonged. The lines between Texas and Arkansas and Louisiana and Arkansas were not known and officially established when Arkansas was admitted into the Union. All right, we're gonna get into this book here, American State Papers, Documents of the Congress of the United States in relation to the public lands from the first session of the 18th to the second session of the 19th Congress, inclusive, commenced in December 1st, 1823 and ended March 3rd, 1827, selected and edited under the authority of Congress by Absuri Dickens, Secretary of State, and James C. Allen, Clerk of the House of Representatives, Volume 6. And we're on page 50 of this book, and it says here, number 431, 18th Congress, second session. Claim of the Baron de Maison Rouge to lands in Louisiana. Communicated to the House of Representatives January 7th, 1825. Mr. Brent from the selected committee to whom was referred the consideration of the report of the Secretary of the Treasury relative to the claim of the representatives of the Marquis de Maison Rouge to a large tract of land situated in the parishes of Washitaw and Catahoula in Louisiana, by a resolution of the House of Representatives of the Congress of the United States of December 23rd, 1824, reported that on March 17, 1795, the governor of Louisiana entered into a contract with the Marquis de Maison Rouge, of which the following is a copy. And this is what we have just read again, the provisions, the letter of who was working with him, Don Joseph Orue, the Karen, Don Francis Redon, and Baron de Carondelet, and then the stipulations, what they're going to offer. Again, we offer in the name of His Catholic Majesty, number 1, number 2, number 3. If you remember, we read this already. So we got that already, the stipulations, what they were going to offer it. Then there's a letter here establishing the claim, by Gardoki, we read that. And then the land surveyor, Carlos Trudeau, which read before, and this is what he's saying. What is the boundaries of the Marquis Maison Rouge land? So this is the same Carlos Trudeau from 1797. Says here, land offices, Opelousas, August 15, 1812. The foregoing is the substance of the process verbal certificate of the surveyor general subjoined to the plot, of which that on the other side is a copy, filled in the claim of Louis Bouligny, holding under Maison Rouge. So it seems is who the Maison Rouge left this land grant that he received to. Now, were they the rightful heirs? And it says, El Charir, translator of the Board of Commissioners. Test El Posey, clerk of the board. I certify that the above in the preceding page is a true copy from the report of the Land Commissioners of the Western District of Orleans, dated December 14th, 1812, and that the plot attached here is a copy of the plot attached to the said report. The original papers copied in pages 67, 68, and 69 of the book, entitled Land Laws Are Not in This Office. Joshua Makes. General Land Office, December 12, 1820. On June 20, 1797, 6 days after the survey is stated to have been made, the Governor General made the following order. All right, this is the Baron's Carolus letter, which we just read as well, saying that the Marquis de Maison Rouge is near completing the establishment of Washitaw. This was in 1797. Then we got a letter from Andres Lopez Armisto, says here, and these are the guys who said, yeah, Marquis de Maison Rouge is completing the contract, he is complying. So they kind of vouched for him. Don Gilbert Leonard and Don Manuel Gonzalez Armides, Spanish officers, says Don Gilbert Leonard, Treasurer of the Army, exercising the function of the Royal Accountant, and Don Manuel Gonzalez Armides, exercising those of the Treasurer, par in term of the Royal Chest of this province of Louisiana. We certify that the two foregoing copies are conformable to the originals which remain in the archives of the Ministry of the Royal Domains under our charge, and that the contractor, the Marquis de Maison Rouge, complied punctually with the terms which he proposed in the said contract, and that this may be made manifest conformably to the order above inserted of this Intendancy General we give the present in New Orleans, August 5th, 1803. So they're vouching to say he completed the contract, right? Gilbert Leonard and Manuel Armides. Now, what did that do? Upon this evidence, the land commissioners, acting under the Act of Congress of March 3rd, 1807, by their report, placed this claim amongst a class of cases recommended for confirmation. So because these two people vouched for him, right, they said, okay, well, it must be good for confirmation. It says here, number 3, claims to land in county of Washitaw. And it says, by whom claims, says Louis Bouligny. Original proprietor or claimant, Marquis de Maison Rouge. Quantity claimed 30 square leagues. That's a lot, out of acres. So it's a Spanish grant from 1797. So Louis Bouligny is now claiming it. The undersigned commissioners have compared the documents title filed in this claim with the translation of them in pages 67, 68, and 69 of the appendix to the book entitled Land Laws, and find the said translation to be correct so far as it goes. The certificate or process verbal which the surveyor general has annexed to his plot, not appearing in said book, a translation of that document together with a copy of that plot is transmitted for the further elucidation of the claim. No oral or other testimony has been adduced before the board to establish the occupancy of any part of these lands. You see? So how did he comply with the contract? Where's the 30 families? They're saying a lot of these lands was never really occupied. There's no testimony, oral history, no documents, anything. Again, no oral or other testimony has been adduced before the board to establish the occupancy of any part of these lands, or that there has been a compliance upon the part of the grantee with the conditions stipulated in the contract, except the certificate under the date of August 5th, 1803, signed by Gilbert Leonard and Manuel Armeres, to the translation of which in page 69 of the appendix of said book, the commissioners beg leave to refer. All right. So what they're letting you know here is that they don't have no proof of any of these 30 families actually establishing themselves. The only confirmation that Maison Rouge complied with his contract was from these two people who said he did. That's it. There's no proof of it. Again, remember, we read in part 2 how they were hiring all the lawyers. They were very known in their city, in their town, very high class, Maison Rouge. So, of course, he had people vouching for him. Now, let's say he did establish the 30 families. How come there's no proof of it anywhere? And what families was that? The undersigned have observed a remark in the 25th page of the introductory part of the book entitled Land Laws, that no patent has issued on the claim under consideration. With great deference for that authority, the undersigned commissioners cannot but be of opinion that the instrument under date of June 20, 1797 is a patent for what was usually in Louisiana denominated a title in form, transferring to the Marquis de Maison Rouge the title in as full and ample a manner as lands were usually granted by the Spanish government, subject, however, to the conditions stipulated in his contract with the government. The plat of survey above referred to will be found subjoined to this report. All claims which did not exceed a league square were confirmed by Act of Congress of April 29, 1816, and this being for a greater number of acres than are contained in a league square was excluded from confirmation by said act and is now presented for confirmation or rejection by Congress. The confirmation of this claim is resisted by the government of the United States upon several grounds, amongst which are the following. First, that the documents relied upon to establish the claim of the representatives of the Marquis de Maison Rouge to the 30 superficial leagues claims show that no contract or grant has ever been made to the Marquis de Maison Rouge in his own individual right or for him personally. It wasn't for him personally. There were stipulations there so Spain can establish wheat business with European families going there to farm it. He was to help with that. It wasn't for his own personal family or his, they saying it here, his own individual right, and that it was only a contract with him as an agent of the persons he was to bring with him, by which the Spanish government bound itself to grant to each person, according to the conditions of the contract, a certain number of acres of land, and that de Maison Rouge did not acquire by said contract a right to dispose of said land by sale, deed, or last will and testament, or in any other way. Okay, so you guys understand that? He couldn't just sell the land, get rid of it, or put it on a will saying, I'm going to give it to the Boulignys, because that's who ended up having it. He ended up giving it to, for some reason, to the Bouligny family, which is probably related to him. He couldn't do that. That was not part of the stipulation. He wasn't supposed to pass on the land to who he wanted to. You understand what they're saying here? Not me. By law, this is what they're saying here. The first stipulation, or the first thing they want to point out. Now, secondly, it says that the conditions of said contract were never fulfilled by the said Marquis de Maison Rouge. There's no proof of it. Thirdly, that the said land never was surveyed as certified under the Spanish government, and if it were, that it was not done with a view to vest the Marquis de Maison Rouge with any right individually. It wasn't for him personally. There's nothing stipulating that. There's no document certifying that it was for him, his right individually, but for the sole purpose of designating a certain number of acres of land upon which the new settlers might establish themselves as they came in, and out of which the promised grants of 400 arpents each was to be made to each family containing 2 white persons. Remember, so-called white, according to the 4th condition in said contract. And the said families not having settled the land as agreed, it remains as public land, because most of it did not get settled. It remained as public land. Fourthly, that the said land never was intended nor never was located as pretended by the representatives of de Maison Rouge, but was at a different place. In support of these subjections and others to the confirmation of this claim, a reference has been made to the documents aforesaid and to the depositions of sundry old inhabitants of Louisiana and of Spanish officers. So they went and asked the people there locally, which were taken by proper authority after due notice given, in which testimony is marked W and accompanies this report. Also to the certificate of Carlos Trudeau, translated by L. de Bouligny on April 17, 1804. There's New Orleans, April 17, 1804. From a careful examination of the foregoing documents and testimony, the committee are of the opinion that the decision in the present claim depends entirely upon a question of law as to the title and upon the examination of witnesses as to several important points to be ascertained, and that an investigation of the claim by Congress will not only be attended with great delay, but with so many difficulties that justice, as well to the parties interested as to the government of the United States, requires a reference of the decision of this claim to the United States Court for the Western District of Louisiana, with an appeal to the Supreme Court of the United States, and for that purpose report a bill. I'm going to read from this book now. It's called Cases Argued and Decided in the Supreme Court of the United States, 1234 Howard, Book 11, Lawyer's Edition, complete with headlines, headnotes, statements of cases, points and authorities of counsel, footnotes, and parallel references by Stephen K. Williams, LLD, 1926. We're on page 771, 772. This is very small, but as much as I can zoom in here on the Google Books. It says here, the United States plaintiff in 773 error versus Richard King and Daniel W. Cox defendants. Alleged Spanish survey certificate declared antedated and forged grant from U.S. will prevail over imperfect Spanish title Spanish grant not connected with survey. What do they mean by that? The certificate of survey alleged to have been given by Trudeau. Remember, Trudeau's the guy who supposedly surveyed the land for Maison Rouge, right? And Clarence Baron Dunlett on the 14th of June, 1797, and brought forward to sustain a grant to the Marquis de Maison Rouge, declared antedated and fraudulent. Listen to this, it was declared fraudulent. Remember that a lot of the lands weren't even showing up in that survey. The circumstance that a copy of this paper was delivered by the Spanish authorities in 1803 is not sufficient to prevent its authenticity from being impeached. Leaving this certificate out of the case, the instruments executed by the Baron de Carondelet in 1795 and 1797 have not the aid of any authentic survey to ascertain and fix the limits of the land and to determine its location. This court has repeatedly decided, and in cases too where the instrument contained clear words of grant, that if the description was vague and indefinite and there was no official survey to give it a certain location, it could create no right of private property in any particular parcel of land, which could be maintained in a court of justice. An equitable title is no defense in a suit brought by the United States. An imperfect title derived from Spain before the cession cannot be supported against a party claiming under a grant from the United States. The Act of Congress of the 29th of April 1816, confirming the grant to the extent of a league square, restricted it to that quantity and cannot be construed as confirming the residue. Queer, whether the acceptance by the claimant of this league square affected his title to the residue. This case was brought up by a right of error from the Circuit Court of the United States for East Louisiana. You see that? It shouldn't have even reached the Supreme Court, is what they're letting you know here. It involved a claim for upwards of 200,000 arpents of land in western Louisiana, commonly known as the Maison Rouge claim, the history of which is this. About the year 1795, a number of French royalists, French royalists, not American Indians, French royalists, arrived in New Orleans. Remember who was very friendly with the French arriving in New Orleans? The Washitaw. They were always friends, remember? Check out part 2. A knight of St. Louis, right? Marquis de Maison Rouge was a knight of St. Louis who had been banished from France and whose property had been confiscated in the Revolution. On the 1st of January, 1795, he obtained the following passport. The Baron de Carondelet, Knight of the Religion of St. John, Brigadier of the Royal Armies, Governor, Vice Patron of the Provinces of Louisiana, West Florida, and Inspector of the Troops thereof, etc., etc. It is hereby permitted Messieurs de Maison Rouge de Brerd and other persons of their suit to pass on to Washita to examine its position and there to form a settlement. In consequence, Mr. de Filhiel will afford them every assistance and the information necessary for that object. Given in our government house at New Orleans, this first day of January 1795, signed the Baron de Carondelet, Andrew Lopez Ernesto. On March 17th, on the 17th of March 1795, the following contract was entered into. We, Francis Louis Hector, Baron de Carondelet. All right, so this is the same contract we read and how he was supposed to bring the 30 families, right? It says here, to propose to us to bring into these provinces 30 families who are also immigrants and who are to descend the Ohio for the purpose of forming an establishment with them on the lands bordering upon the Washita, not this Washita tribe, but the Washita River, a landmass, designed principally for the culture of wheat and the erection of mills for manufacturing flour under the following conditions, right? So there we go, the 5 stipulations, which we already read. And then we got the letter by Gadorki, who confirmed and vouched for Marquis. So after Gardegori wrote, it says here on the 12th of August, 1795, the following letter was addressed to the Marquis de Maison Rouge. New Orleans, August 12, 1795. Sir, I have received the honor of your letter of the 25th of June last with a statement of the families. Your perseverance in the opinion you have formed of the excellence of the land you inhabit, in which you are going to make flourish for the happiness of this province, as well as for those in its neighborhood which ought to partake of these advantages, ought to animate you to make the greatest efforts to effect this early accomplishment. All right, so this is when they were just saying, yeah, we're going to do this, we're going to do that, we're going to establish it, we're going to do good. So that's what he's saying. So hopefully this will animate you to make the greatest efforts to effect its early accomplishment. Make sure you accomplish it. It hasn't accomplished yet. The picture you draw of these enchanted places convinces me of the solidity of your judgment and of the fortunate selection you have made in your plan, as well as the facility of the means to carry it into execution in all its branches. I have paid Mr. Mariot the $300 for Alexander Laurent, Peter Relly, and James Ferret. By this opportunity, I informed the commandant of what is to be done when any new family arrives, giving him distinctly to understand that if the least formality of a certificate is wanting and not conformable to the copy which I sent him, no payment whatever will be made from the royal treasury. I have the honor to be, with respect, sir, your very humble and most obedient servant, signed, Francisco Rendon. All right, so he's saying, oh, I'm your servant. Why is he a servant of de Maison Rouge? Who's de Maison Rouge? Remember, they were saying this might be King Louis, but the timelines ain't matching here. So he's still investigating all this, all right? But he did call him here. He's saying he's a servant of Mr. de Maison Rouge. On the 26th of August, 1796, the following letter was written. Under this date, I have written to the Commandant, John Filhill, as follows. By the certificates which you sent me in behalf of the individuals who were brought here lately by the Chevalier Baird, I learned that there were among them many single men who cannot, a lot of those single men, right? Who did these single men marry? A lot of these single men coming from Europe, right? Single men who cannot therefore be considered as composing families. I thought you were supposed to bring families, not single men. You see what the stipulations already going wrong. And consequently, they ought not to have received the $100 stipulated in the first article of the contract which the Marquis of Maison Rouge made with the governor and intendant of the province. They already broke a stipulation there. On this occasion, we passed over this irregularity in order to avoid disputes in future, it being inconsistent with the spirit of the contract and of no use to the interest of the king to spend the public money on individuals who, having no inducements to remain in the country, could leave it with the same facility they came, right? Because they don't have a family, they have no attachments. They want people to have families so they can live there and multiply and stay there and create towns and stuff and colonize. It must not occur again, and inform the Marquis that there are no funds in the public treasury destined to that object. He's warning these people. This is somebody writing. We're going to find out who it is writing, but he's letting them, hey, I ain't going to be paying money for these single men coming over here. That wasn't part of the deal. We want families. Make sure you inform the Marquis that there are no funds in the public treasury destined for that object. There ain't no money for that. And that as soon as he has completed the number of 30 families, which he contracted for, that's what he really contracted for, 30 families, nothing will be paid out of the royal treasury to any who should exceed that number and who wish to come and establish themselves in this district. And you will consider yourself instructed to this effect and conform to it in future. They're telling him, you better conform to this, Marquis, advising me in conformity of what is done in the premises. I consider you as the agent and authorized to act for the Marquis of Maison Rouge in the business of bringing families to that post, and therefore communicate this for your government and information. The Lord preserve you many years. Signed, Juan Ventura Morales. All right, Morales. Morales ain't playing. He's saying, yo, you guys are bringing single men over here. I thought we told you families. We ain't gonna give you money, and you better tell the Marquis of Maison Rouge to follow the instructions and the stipulations that he contracted for. Now it continues here, it says, in the latter part of the year 1799, Maison Rouge died. 1799. Maison Rouge died in 1799. Remember, we found that funeral record in the last video, part 2, with Joseph Maison Rouge saying he was born around 1730s, I believe, France, and died in 1799 in Louisiana. All right, so how do we get to Henry Turner, supposedly in the 1840s? So after he died, leaving a will which was dated on the 26th of August in that year, it was as follows. So this is a will that Maison Rouge left, supposedly, right, in 1799. Now remember, it said earlier, we read that he was not supposed to leave the land in any will. That wasn't part of the contract or stipulation. But let's see what it says here. It says, first, recommending my soul to the same Lord God who gave it to me, and created and redeemed it at the price of his most precious blood, passion, and death. I implore him by the most holy bowels of his divine mercy, that he will pardon it and send it to eternal rest among the chosen for which it was created. My body I ordered to be placed in the earth, out of which it was made, and when I die, I desire to be buried in the plainest manner, and that my funeral shall take place in such place as my executor chooses, to whom I leave the management of the rest of my funeral and interment, in order that he may act as to him appears best, such being my will and pleasure. I also direct that 3 masses be said for the rest and repose of my soul, for each of which 3 bits of rials shall be paid once, and to each of the donations into which my goods and effects are divided. I also declare that I am a bachelor, that it may so be made manifest and certain. All right, he said he's a bachelor. What wife? I also declare and make known that I possess property in Paris, Berry, and Quarry, which was confiscated, of which I possess no documents to establish my claim. So he had no documents for that land. So how did you get it? I also declare that I possess in Washita a house and land, which I give and bequeath to my servant maid called Maria, an Irish woman, such being my wish and pleasure. Listen, remember in part 2, and the funeral record says that even though it says that he didn't have no children, that he left a set of twins with this Irish Maria, Maria, Irish, the Irish women, indentured servants. They were sending them here by the thousands. So again, he's leaving that land in Washita, the land in Washita in his house, in the Washita Valley River, to his servant maid called Maria, an Irish woman, such as being my wish and pleasure. Remember who the Irish back then, talking about black Irish. I also declare that I owe some small sums to my work people, which I desire to be paid from the present harvest. I also name as my executor and property holder Mr. Louis Bouligny. All right, so listen, he's giving it to Louis Bouligny. Why? Whom I empower and give authority to after my death to take possession of my goods and property. All right, as you can see, there is no Turners here. He's not giving it to any Turners so far, right? And no Aya Maria from Washitaw tribe. He said Maria, an Irish woman. Not Aya Maria, but Maria, an Irish woman. So he's leaving Maria some land in Washita and the rest of his property and estate to Louis Bouligny, his main executor. So after my death, says here, to take possession of my goods and property without the intervention or interference of judicial proceedings, to make inventories, valuations and sales thereof, to appoint such appraisers and he chooses, and to adopt all necessary proceedings until my mortuary affairs are concluded and wound up, for which purpose I postpone and extend a year of executorship and further time which may be necessary for that purpose, and such is my will and pleasure. I also declare that I have at the house of Don Pedro all the articles necessary to build a sawmill for cutting plank and a pump auger. I also desire and declare that in the donation which by this will I make to my servant maid Maria, slash mistress slash girlfriend of a house and a land, there is only included 5 acres front by the usual depth, and the aforesaid house, and not the rest or other land, such being my will and pleasure, and the residue and remainder of my goods, rights, and actions as well within as out of this province, in case my parents are dead. In case my parents are dead, who's your parents? I constitute his parents weren't the king and queen. Remember, king and queen got beheaded if that's King Louis. In case my parents are dead, I constitute and name for my sole and universal heir the aforesaid Louis Bouligny. So why is the Bouligny his heir? In order that after my decease he may have and inherit them with the blessings of God and myself, and such is my will and pleasure. I revoke and annul and declare void, cancel, of no value nor effect whatever any other wills and testamentary dispositions I may have heretofore made by word or in writing, which I desire no faith or value shall be attached to, save and excepting this, which I present authorized and declare in such manner and form as may stand good and right. All right, so he left all his land and all this stuff to Louis Bouligny. Why not his kids, right, that he had with Maria? Remember, he supposedly had a set of twins with her. And you think Joseph Maison Rouge or this Maison Rouge never had no children? You know? And what's up with Maria? Who is Maria? We got to find all this out, right? Continues, says, in favor of which this instrument is dated in the city of New Orleans, the 26th of August, 1799, so 1799. I, the notary, give faith to and know the declarer who, to appearance, possesses his natural judgment, memory, and understanding, and signed it in the presence of Don Andres Lopez de Armesto, honorary commissary of war and secretary of this government, Don Pedro Condillo and Don Vicente Tejido Lientard, inhabitants, de Maison Rouge. In 1802, Bouligny went upon the ground and caused a survey to be made by McLaughlin, who had been a deputy surveyor under Trudeau. In 1803, Daniel Clark applied for and obtained from the Intendant General of New Orleans copies of the contract with Maison Rouge and of the order of the 14th of July, 1795. Congress having passed an act for the purpose of ascertaining the rights of persons to land within the district and territory of Orleans, the commissioners appointed under the act reported upon Bouligny's claim as follows. Class B, in which the claim was placed by the commissioners, is thus described by them. To the second class comprising claims which, though not embraced by the provisions of the said acts, ought nevertheless, in the opinion of the commissioners, to be confirmed in conformity with the laws, usages, and customs of the Spanish government, the letter B will be affixed. By an act of 29th of April, 1816, the claims marked B were confirmed, provided, nevertheless, that under no one claim shall any person or persons be entitled under this act to more than the quantity contained in a league square. So now we're getting into another person's case of land right here in Louisiana. He's this guy, defendant Cox, and he's going to be using the Maison Rouge grant as part of his case. Let's just read about what he has to say and what happened to him. When we're talking about this claim, right? This land claim. It says in 1841, the defendant Cox, who had become owner of this claim, applied for patents for a league square, which were accordingly given to him under the circumstances stated in the opinion of the late Mr. Attorney General Legare, under the date of 22nd of December, 1841. On the 13th of February, 1843, the United States, by Bailey Payton, their attorney, filed a petition in the Circuit Court of the United States stating that Richard King had taken possession of and claimed title to a part of the land. The petition prayed that the land might be adjudged to belong to the United States, etc. King answered and called Cox and warranty, who also answered and set forth his title and extenso under the grant of Maison Rouge. So Cox is using the Maison Rouge grant, and this other guy, King, is using some other thing to say, this is my land. On the 10th of July, 1843, the court, after argument, pronounced the following decree. The court, having maturely considered the law and the evidence in this case, doth now order, adjudge, and decree that the plaintiff's petition be dismissed and that the grant made by the Baron de Carondelet as the governor of Louisiana on the 20th of June, 1797, to the Marquis de Maison Rouge be, and the same is hereby declared valid, that the said Richard King, the defendant, and the said Daniel W. Cox, warrantor, be, and they are hereby declared and recognized to be the lawful owners of the parts of that said grant held by them as described in the answer of the said Richard King, and in the Schedule A, and that they be quieted in the ownership and possession of the same. Theo H. McCaleb, U.S. Judge. All right. In the course of the trial, the United States filed 5 and the defendants 3 bills of exceptions. The following were assigned as errors on the part of the United States. That in the matter stated in the several bills of exception, not necessary here to be restated, the court below committed an error. That the evidence in the case does not sustain the claim of the title of the defendants to the lands in controversy. That the acceptance by the defendant, Daniel F. Cox, of a patent for 1 league square of said land under the Act of Congress of the 29th of April, 1816, operates as an extinguishment of his title to any other portion of said land. The evidence referred to in the second point of error was very voluminous. It consisted of a number of letters written by the Baron de Carondelet, by the Marquis de Maison Rouge, and by others, and of the deposition of sundry persons, all of which is impossible to insert at length or to compress within a reasonable compass. Mr. Nelson, Attorney General for the United States. Mr. Cox for the defendants. Mr. Nelson, after referring to and explaining the papers above cited, laid down 4 propositions which he proposed to maintain. Number 1, that the paper relied upon by the defendant is not a grant. Number 2, that assuming it to be so, it was to take effect upon conditions which were not complied with. Number 3, that the paper purporting to be a survey by Trudeau is a forgery and covers land not covered by the grant. The Trudeau thing, Number 4, that the grant is void from indefinitiveness and cannot be located. As the decision of the courts turned upon one of these points only, it is deemed unnecessary to report the arguments of the respective counsel upon the other points. That the paper purporting to be a survey is a forgery And apart from that paper, the grant contains no description. It is remarkable that no one ever saw this survey. You see, they weren't paying attention. They were saying, oh yeah, this is verified. This is by survey, boom. They were just paying people to do this thing. Corruption. So it's remarkable that no one ever saw this survey, although professing to have been made in 1797 until 1803. It was not appended to the grant. In 1802, there was a grant by Trudeau to Phil Hill of land below Fort Miro, and yet the survey made in 1797 calls for Phil Hill's line, which was not established until 1802. Uh-oh, they got caught. You see, so that Trudeau survey is from a different time period. It's not from the time Maison Rouge was alive, because Phil Hill's line wasn't even established until 1802. So how could it be in a survey in 1797? They didn't exist. Moreover, this grant to Phil Hill says that his land is bounded on every side by vacant lands. And yet, if the former survey were genuine, Phil Hill's grant was in the midst of the land which had been granted to Maison Rouge, right? It should have been filled with 30 families. Mr. Nelson then examined minutely the testimony of various persons of Mr. Phil Hill, the commander of the post of Washitaw, from 1783 to 1800, of the widow Bayergion, of Mr. Pormier, a settler under the contract, of Mr. Bellin, of Mr. McLaughlin, who said that Trudeau was never on the spot and never had any other deputy surveyor than himself. You hear that? The people who lived there say, no, that's a lie. That guy never came to survey here. He was never here. I'm the surveyor. In 1802, Bouligny went out to the spot and had a plat made by McLaughlin, who says that the plat dated 14th June 1797 is copied from the one which he made in 1802. Listen, this happened in 1802. This is after Maison Rouge died. Mr. Cox, for defendants, gave a history of the case and referred to various state papers, reports of a committee Senate, U.S., July 20th, 1842, instructions of Solicitor of the Treasury, December 23, 1842, American State Papers, June 9, 1813, Land Laws, 744, 745, Green's Public Lands, 247, in One Laws, U.S. Brown's edition, 549, this title is set out just as it is in the present record. In Two Land Laws, American State Papers, 771, 774, there is a copy of the very plot which we have. It is objected that no one ever saw Trudeau's certificate of service until 1803. At the foot of the grant in Spanish, which is in the records, are these words: anotado en el libro A, número 1, vergo 38 y copia sicada. So this was an annotated or noted down on Book A, number 1, verse 38. What became of the Book A, we do not know. In American State Papers, Public Lands, Volume 2, page 774, there is a translation of Trudeau's certificate of survey with the following remark: Land Office, Opelousas, August 15th, 1812. The foregoing is the substance of the process verbal certificate of the Surveyor General's subjoined to the plot, of which the annex is a copy, filed in the claim of Louis Bouligny, holding under Maison Rouge, S. Charis, translator to the Commissioners L. Posey, clerk of the board. All right, so again, that's from 1812. If there is any defect in the record, the government must bear the consequence, for all the Spanish books were handed over to the public authorities. It is the first time that this paper was ever denounced as a forgery. The grant itself says marked in a plan annexed, showing that some plan was annexed to it. The evidence of Tessier verifies it. He was a principal clerk in the office for making grants of land under the Spanish government, and this grant is in his handwriting. He says he cannot recollect whether he had or had not Trudeau's figurative plan and process verbal before him, but he is certain that he performed his duty either by dictation or written instructions of his superiors, or by seeing the document B, though he cannot say in which of the three respective modes he acted upon this occasion. The guy's like, I don't know, I can't remember exactly. The decision of the Board of Commissioners is final against the United States in the case of McDonald versus Millaudan. decided at this term. The court says that a complete grant requires no confirmation by Congress. The limit to a league square in the confirmatory act does not negative the residue of the title. There are no words to that effect. The proviso was put in because it was thought that Spanish governors could not grant more than a league square. This court entertained the same doubt. 4 Peters 5:11. Congress could not annul the title to the land beyond a league square because it rested on a treaty. The act does not profess to annul it, but leaves it where it found it, subject to judicial decision. This construction of the act reconciles it with justice and good faith, and these considerations were held to be operative in 2 Wheat 203 and 6 Peter 7:18. The United States never claimed what was severed from the public domain. Our title, therefore, is equal to a patent and can only be assailed on the ground of fraud. This is a charge which is easily made. It is not pretended that any was practiced on Carondelet, nor is the signature of Trudeau denied, but it is said to be antedated. The United States knew all about these papers, but the petition in this case does not allege fraud. It is true that the defendants are said to have no title, but suppose we were in Chancery, would the court permit a party to raise such a question upon the trial if it was not alleged in the bill? It ought to have been put in issue and evidence taken upon it. In that case, the onus probandi would have been made upon the United States. By the treaty, they became possessed of all vacant domain and must make out their title. It will not do to claim all and make the defendant show his title. Peters 298, 2 Butcher's Land Law 669. The fraud here is charged upon high functionaries of a foreign government 48 years ago. Fraud for what purpose? There was no motive for it. Carondelet might have made the grant if he chose. He had the power to do it. Both these papers were before Congress in 1820, and the defendant met the accusations which were then brought against him. The United States have never attempted to resign this patent for 20 years. If they were a private person, they would be bound by their acts. The accusations of fraud now made by the Attorney General rest on 2 grounds. A pamphlet published by Gerard on evidence taken in another suit. With regard to the pamphlet, it has been answered in the same way. With regard to the other, the evidence was taken under a notice, served by a hostile party before another hostile party, all on the same day, and the suit then not prosecuted. Mr. Cox then examined this testimony. Mr. Nelson in reply and conclusion. This is a mere question of title to be settled on principles of law. The defendant claims under a grant from the Spanish government. The treaty gave the public domain to the United States. There is no contest about their title. If the land had not previously been granted by Spain, we concede freely that the United States only succeeded to the rights of Spain, and that all grants, perfect or imperfect, are binding. If the rights were imperfect, the United States are bound in equity to carry them out, but not this branch of the government, which can look only at the legal title. Is this such? But first, let us examine a proposition laid down by the other side, that this claim has been recognized by all the departments of the government. If so, the United States must be stopped. If Congress has conferred a title on the representatives of Maison Rouge, there is an end of the question. So if the judiciary has recognized it, but no misapprehension of the executive on such a subject is binding on this court, Mr. Chief Justice Taney delivered the opinion of the court. In this case is one of the great importance from the amount of property in dispute. And if the court entertain any doubt upon the questions of law or of fact which are presented by the record, we should regard it as our duty to hold it under advisement and postpone the decision to another term. But the principles of law upon which it depends are not new in this court, and have often been the subjects of discussion and consideration since the cession of Louisiana and Florida to the United States, and having, after a careful examination of the evidence, formed a decided opinion upon the facts in the case, we deemed it proper to dispose of it without further delay. The claim in question arises upon 2 instruments of writing, executed by the Baron de Carondelet, civil governor of Louisiana, one 1795 and the other in 1797, the latter of which is alleged by the defendant in error to be a grant to the Marquis Maison Rouge for the land included in a plot made out by Trudeau, the Surveyor General of the province, and dated 14th of June, 1797. and which survey embraces the land in controversy. It is insisted on the part of the United States that this certificate of Trudeau is antedated and fraudulent. Okay, it's not from 1797 as they're saying, it's very fraudulent. And in order to determine the state of the facts upon which the questions of law will arise, the authenticity of this survey will be the first subject of inquiry. Upon this point, a good deal of testimony has been taken upon both sides, but it would extend this opinion to an unreasonable and unnecessary length to enter upon a minute comparison and analysis of the testimony of the different witnesses and of the other evidence contained in record. It is sufficient to say that after an attentive scrutiny and collation of the whole testimony, we think it is perfectly clear that this certificate of Trudeau is antedated and fraudulent, and we refer to the evidence of Filhill, McLaughlin, and Poinier as establishing conclusively that the actual survey upon which this certificate was made out did not take place until December of 1802 and January 1803, and that the one referred to by the governor in the paper of 1797 was for land in a different place and higher up in the Washitaw River. We are entirely convinced that the survey now produced was not made in the lifetime of the Marquis Maison Rouge, who died in 1799, but after his death, and at the instance of Louis Bouligny, who according to the laws of Louisiana was what is there termed the forced heir of the Marquis' forced heir, and that it was made in anticipation and expectation of the cession of the country to the United States, the negotiations upon that subject being then actually pending, and the Treaty of Cession signed on the 30th day of April 1803. We see no reason to doubt the truth of the witnesses to whom we have referred. On the contrary, they are supported by the testimony of other witnesses and by various circumstances detailed in the record. All right, that land survey that Trudeau made from sentence is fraudulent. It's a lie. He did it in 1802, 1803. You guys understanding? Following along? This is stuff that, you know, the Washita Nation will never really go into. They probably don't even know this, a lot of this stuff. You have to go into the records and the court cases to understand all this stuff. It has, however, been argued that inasmuch as an attested copy of this certificate, with the two instruments executed by the Baron de Carondelet, were delivered to Daniel Clark in August 1803 by the Spanish authorities at New Orleans upon his application for the documentary proofs of the title to this land, the authenticity of the paper in question ought not to be impeached, and that it is inconsistent with the comity due to the officers of a foreign government to impute to them fraud or connivance in a fraud in an official act where their conduct has not been questioned by the authority under which they were acting and to which they were responsible. This proposition is undoubtedly true, where no other interest is concerned except that of their own government or its citizens. And as regards the interests of others, the acts of the officer in the line of his duty will prima facie be considered as performed honestly and in good faith. And although this certificate and other documents were delivered to Clark after the country had been ceded to the United States, yet as possession had not been taken, and the evidences of titles to lands in the ceded province were still lawfully in the hands of the Spanish authorities, the documents upon that subject obtained from the proper officer ought to be regarded as genuine unless impeached by other testimony. So because even though this was still after the land sale, things were still in transition. The Spanish still had hold there in that land. They were still doing things. They were still there trying to do certain things with the land and business and the land grants and all that. But it would be pushing the comity usually extended to the tribunals and officers of a foreign government beyond the bounds of justice and the usages of nations to claim for them a total exemption from inquiry when their acts affect the rights of another nation or its citizens. Certainly, the political department of this government has never acknowledged this immunity from inquiry, now claimed for the Spanish tribunals and officers, and in every law establishing American tribunals to examine into the validity of titles to land in Louisiana and Florida derived from the government of Spain, they are expressly enjoined to inquire whether the documents produced in support of the claim are antedated or fraudulent. and we have no doubt that it is the right of this court to hear and determine whether the certificate of Trudeau, although recognized and sanctioned by the colonial authorities of Spain, so Spain made this official when they were still in power. They say, oh yeah, that's a good, yep, that was from 1797, yep, that was correct, yep, that's ours. It is antedated, okay? It was still antedated and made out either with or without their privity and consent in order to defraud the United States and to deprive them of lands which rightfully belong to them under the treaty, and that it is our duty to deal with it as the evidence may require. We desire, however, to be understood when speaking upon this subject and not intending to charge the present claimants with having participated in the fraud, but from the testimony and the record, we are fully convinced that it was committed in the manner herein before mentioned by Bouligny, under whom they claimed title. So this was during Bouligny's time that this was going on, and he probably paid Trudeau and all. He paid people to get this going. This is the person. So they're saying, we're not blaming you guys who are using this grant as being part of the fraud, but fraud was committed, right, during the time herein before mentioned by Bouligny, under whom they claimed title. Remember, that's the guy Joseph Maison Rouge supposedly left everything to in his will, the forced heir. Regarding the case, in this point of view, the right of the defendant in error must stand altogether upon the instruments executed in 1795 and 1797 by the Baron de Carondelet, and it has not aid of any authentic survey to ascertain and fix the limits of the land and to determine its location. The instruments themselves contain no lines or boundaries whereby any definite and specific parcel of land was severed from the public domain, and it has been settled by repeated decisions in this court. And in cases too, where the instrument contained clear words of grant, that if the description was vague and indefinite, as in the case before us, and there was no official survey to give it a certain location, it could create no right of private property in any particular parcel of land which could be maintained in a court of justice. It was so held in the cases reported in 15 Peters 184, 215, 275, 319, and in 16 Peters 159. I guess that's volume 16 of Peters, right? Page 159, 160, in case you guys don't understand this. They're not talking about biblical verses here, just in case. After such repeated decisions upon the subject, all affirming the same doctrine, the question cannot be considered as an open one in this court. Putting aside, therefore, and rejecting the certificate of Trudeau, for the reasons before stated, the instruments in question, even if they could be constructed as grants, conveyed no title to the Marquis de Maison Rouge for the land in question. So now, apart from that survey being fraudulent, now let's go back to the original grant. Still, the grant gave no personal, individual right or title to Marquis de Maison Rouge for his personal use for the land in question, and consequently, the defendants in error can derive none from him. They cannot use him. They cannot use him. You understand? You cannot go to court using the Maison Rouge land grant to try to get land back to you, because he had stipulations. Marquis de Maison Rouge, whoever this guy was, and however he's related to the terms, because we still haven't seen no connection, it was not for his personal use to be given away to any heir he chose. Consequently, the defendants in error cannot derive none from him. They cannot use this in court, any of those land grants. The land claim was not severed from the public domain by the Spanish authorities and set apart as private property, and consequently it was passed to the United States by the treaty which ceded to them all the public and unappropriated lands. It is unnecessary, therefore, for the decision of the case to say anything in relation to the construction and effect of these two instruments, or the purposes for which they were intended. As relates to the claim of an equitable title arising from the number of immigrants alleged to have been introduced under those instruments, it would not avail the defendant in error in this action, even if the proofs showed a performance equal to that contended for on his part. For if these instruments were regarded as grants, and it appeared that the Marquis de Maison Rouge had originally selected this very district as the place where the grant was intended to be located, and the immigrants introduced by him had been settled upon it in performance of the conditions of his contract, and if it should be held that he had thereby acquired an equitable right to have the quantity of land mentioned in the paper of 1797 laid off to him at this place, still it would be no defense against the United States. For in the case of Choteau and Eckhart, right, 2 Howard 375, this court decided that an imperfect title derived from Spain before the cession would not be supported against a party claimant under a grant from the United States unless it had been confirmed by an act of Congress. The same point was again fully considered and decided at the present term in the case of Hickey versus Stewart. These decisions stand upon the ground that such titles are not confirmed by the treaty itself so as to bring them within judicial cognizance and authority, and that it rests with the political department of the governments to determine how and by what tribunals justice should be done to persons claiming such rights. If therefore this controversy was in a court of equity, and no suspicion of fraud rested upon the claim, yet it could not be supported against a grantee of the United States, because Congress has not confirmed it, nor authorized any other tribunal to determine upon its validity. This case, however, is in the court of law, the petitory action brought by the United States and the Circuit Court of Louisiana being in the nature of an action of ejectment in which the decision must depend on the legal title, and that the title under the treaty cession being in the United States an equitable title, if the defendant in error could show one, would be no defense. Still would be no defense. All right, we're in this website, Justia, U.S. Supreme Court. You can find a lot of court cases here online. And it says here, United States versus Turner, 52 U.S. 663 1850. United States versus Turner. Appeal from the District Court of the United States for the District of Louisiana. Syllabus. The decision of this court in the case of the United States versus King and Coxey. And we just read that. And how, again, affirmed that the contract between the Baron de Carondelet and the Marquis de Maison Rouge conveyed no interest in the land to Maison Rouge, but was merely intended to mark out by certain indefinite boundaries the limits of the establishment which he was authorized to form. Again, letting you know this was not for his personal use to give away. The absence in this case of the royal order of 1795 and of all testimony respecting the genuineness of the certificate of survey by Trudeau makes no difference in the decision of the court. The construction of the grant was the main point of that case, and is also of this. Whether or not the instrument was a perfect and complete grant by the laws of Spain was a question for the court and not for the jury. Just wanted to go ahead and include this, United States versus Turner. Everybody's always asking me, and I want to explain to everybody that this was not in a Supreme Court decision, the 1840 Turner case. And again, they're using the King and Cox case we just read because it's just the same thing. You cannot use the Maison Rouge as your case because he was not supposed to give that land away. Now it says here, this was a petition filed in the district court by the appellees who claimed a tract of land under the Maison Rouge grant. They're talking about the King and Cox. The district court decided in favor of the petitioners, and the United States appealed to this court. Mr. Chief Justice Taney delivered the opinion of the court. So again, we already read the opinions of Chief Justice Taney in the last book we were reading, but again, we're going to quote it again, and here it is. It says, "It will be observed that this contract contains no stipulation in favor of Maison Rouge. All the engagements on the part of the government are in favor of the immigrants, who should accept the conditions. Indeed, it seems to have been no part of the purposes of this agreement to regulate the compensation which he was to receive for his services. Its only object, as appears by the concluding sentence, was to make known the offers made by the Spanish government to those who were disposed to come. It was therefore to be shown by the Marquis to those whom he invited to remove to this establishment, and it does not appear to have been thought necessary, and perhaps was not desirable, that his compensation or his interest in forming the colony should be made public." So they didn't say, yo, if you help us with this, we're going to give you this. This is your payment. This is your land. That wasn't stipulated yet, or was not made public. That was a matter between him and the Spanish authorities, which doubtless was understood on both sides. And whether it was to be in money or in future grant of land does not appear. So whether he deserved anything, I'm sure people always deserve something, right, for helping out and doing things like this, especially for governments and royal families and all that. But that was not put into the contract. So again, whether it was to be in money or in future grants of land does not appear. Certainly, it was not to be in the land on which this establishment was to be formed, because the government was pledged to grant it to the colonists, not to you, Mr. Marquis, and to Louis Bouligny, who you left it to, and to single males you were bringing in. The question which this appeal brings up is therefore res judica, nor does the court perceive any ground for doubting the correctness of the opinion heretofore pronounced, and in the case arising under the claim of the Baron Bastrop, in which the judgment of the court has just been delivered, the principles decided in the case of United States versus King Cox have again been affirmed. After full argument by counsel and reconstruction of the court, the Bastrop claim was upon an instrument of writing similar to that in the favor of Maison Rouge and executed on the same day of the Baron de Carondelet for a still larger tract of country than that destined and appropriated for the establishment of the Marquis de Maison Rouge. Undoubtedly, the validity and the effect of both of these instruments depend altogether upon the laws, ordinances, and usages of the Spanish government prevailing in the province of Louisiana at the time they were made, and it is duty of the court to expound them accordingly. And they are both strikingly unlike the grants for colonization authorized by the laws of the Indies, and equally unlike the grants usually made by the Spanish authorities to persons undertaking to introduce into the province a certain number of colonists. And grants of this description authorized by the laws of the Indies and usually made by the provincial authorities, the colonists were introduced by the grantee free of expense to the government, and the grant was the equivalent for the service performed, and depended upon the number thus brought in. And in such cases, the intention to grant as private property was always indicated in clear and appropriate words. So if Maison Rouge was to receive any of this land so he can pass it on to heirs, that would have been stated. It would have been indicated. That's the usual grants at this time. It would have been clear and appropriate words which severed the land at once from the royal domain and converted it to private property. That way it would have not been part of the treaty in the Louisiana Purchase. You guys get it? But in the cases of the Bastrop and Maison Rouge, the colonists are to be brought in at the expense of the government itself and supported for some time afterwards, and they are to receive their grants for the land allotted to them from the public authorities and not from the Bastrop or Maison Rouge. There would seem therefore to be no equivalent or consideration for these extensive grants, and certainly there are no words in either of the instruments that indicate an intention to convey to them as private property the land delineated for their respective establishments. On the contrary, as the colonists were to receive their titles and grants from the government, it follows necessarily that the entire title, legal and equitable, must have remained in the government and have been so understood by the parties, for otherwise this stipulation could not have been performed. And if the land designated for the establishment remained national property and was not severed by these instruments from the national domain, it passed to the United States as public property by the Treaty of Cessation. And again, here we're at the Library of Congress. It says here, U.S. reports United States versus Turner, 52 U.S. 1851. I'm going to go ahead and go into this. Again, most of this is already information we've already read today. I just want to show you who is involved really when it comes to the Turner. What they're talking about Turner, right? Now it says here, the United States appellants, right, versus Sarah Turner, who's the wife of Jared Tyler, not Henry Turner. Remember they were saying Sarah Tunica or something was married to Henry Turner? Well, not this Sarah. So this Sarah's married to a Jared Tyler, who is authorized and assisted herein by her husband. And then it says, Eliza Turner, wife of John A. Quitman, who is in like manner authorized and assisted by her husband. So Eliza Turner and Sarah Turner are the ones bringing this up. Are they sisters? Are they related to Henry Turner or Joseph Turner? Now, what's interesting about this is, if you guys remember my Moorish video series with Drew Ali, this is one of the set of parents that he is supposed to have, which is Eliza Turner and John A. Quitman. Now, it actually might be John Washington Drew Quitman. All right, that's what I got. But I want to point that out, that Sarah Turner is married here to a Jared Tyler, right? And then it says Eliza Turner married to a John Quitman. And then it says Henry Turner and George W. Turner, heirs and legal representatives of Henry Turner deceased. So what does that tell us? That there's two Henry Turners. There's two Henry Turners. There's a junior and a senior, right? There's not just one. So there's obviously a Henry Turner who's deceased that these people are representing in the 1840s, right? And remember, Maison Rouge died in 1799. So how does it connect to all these Turners? How did the Boulignys connect to the Turners? Because the Boulignys is the one who inherited. Now look what they say right away when it comes to the Henry Turner, or when it comes to the Turner versus United States case. The decision of this court in the case of the United States versus King and Cox, right, one we just read, again affirmed that the contrast between the Baron de Carondelet and Marquis de Maison Rouge conveyed no interest in the land of Maison Rouge, but was merely intended to mark out by certain indefinite boundaries the limits of the establishment which he was authorized to form. It says here, the absence in this case of the royal order of 1795 and of all testimony respecting the genuineness of the certificate of survey by Trudeau make no difference in the decision of the court. The construction of the grant was the main point of what the case and is also of this. So again, they're using that same case to basically rule out the Turner versus United States. This was an appeal from the District Court of the United States for the District Court of Louisiana. It was a petition filed in the District Court by the appellees who claimed a tract of land under the Maison Rouge grant. The District Court decided in favor of the petitioners, and the United States appealed to this court. So they won in the District Court locally. Now remember, you got money, you can pay the best lawyers. You know, they're looking at the, they're not really seeing if the land survey is good or not, or what the stipulations of the grant was. It was submitted by Mr. Crittenden, Attorney General for the United States, upon the ground that this court had already decided in the case of United States versus King that the grant was invalid. You see that? So it was very same case, very same situation. And so because they already had, you know, ruled in that case the same exact situation that it was invalid, so they're using the same in the Turner versus the United States case, guys. You understand? You can't send me this saying, but look, it happened. Yeah, that was a district court. It got overruled and appealed by a Supreme Court, and for good reasons. For good reason. And again, they're going to give the opinion here of Chief Justice Taney, which we already got. And he already said, nope, it was not for his personal right. He cannot give it to the heirs. He was not supposed to sell it. All right, so I just want to show you guys that, you know, that's what the Turner case is. It got appealed. And that makes no difference in what the stipulations of the grant was and how he was supposed to settle 30 families and not keep that for his own use. So again, even though there was a case, United States versus Turner, and they were able to win a district court case, there was an appeal. There was an appeal by the United States to the Supreme Court. All right, so real quick, documents relating to the foreign relations of the United States, volume 14. Just to let you know, show you guys that this court case and what they had decided, not just one from 1840s, right? But the whole case, how it worked, how it finished, how it was started, what are the stipulations. It's on a lot of books here. As you guys can see, the same things we have been reading. I didn't read the Bastrop de Carondelet case, what they were arguing, his conditions, but I want to show you guys here what they're saying, the Baron de Carondelet. So remember, this is the guy who gave the grant to Maison Rouge. So first, I want to show you guys that even himself didn't have an individual right. Now it says here, so that the land commissioners of the United States having refused the confirmation of this claim as aforesaid, the owners now present themselves and ask that Congress will confirm to them the aforesaid 12 leagues square, which they claim as deriving a legal title from the Bastrop. From the evidence and documents which have been before the committee, it is proven that many persons were introduced under the contract of the Bastrop. All right, many persons, that included Maison Rouge, but not to the number contracted for, and without touching the question as to the individual right of the Bastrop, his individual right to the land, or of any person claiming under him, like Maison Rouge, by purchase or otherwise, except those who came to Washitaw under the contract. The committee think that in equity, the government of the United States ought to confirm to every person or those claiming under them who went to Washitaw under the contract with the Bastrop the number of acres of land which the government general of Louisiana agreed to give to each family or person according to said contract. The government of the United States resists the confirmation of this claim to the Bastrop or those claiming under him, Maison Rouge, by purchase or otherwise, for the following reasons. All right, this is what they're saying. No, it's not legit. First, that the contract and grant, if any there was, were for the 500 families the Bastrop was to settle upon the land. As remember, Maison Rouge was supposed to settle 30 of those for him. That's why he needed Mason's help. He had different people helping him. Out of those 500, Maison Rouge was going to bring 30 for him. And not to the Bastrop and his individual rights. So it was for the settlers, the land. It wasn't for him, just like Maison Rouge. It wasn't for him, his individual rights, so that he could sell or dispose of the same. So he couldn't sell the land or give it to any heirs. And he did. Secondly, that the conditions never were fulfilled. He never settled the 500 families. Thirdly, that the contract was revoked by the Spanish government. It was revoked eventually. Fourthly, that the contract was never approved by the King of Spain. All right, this is history right here. Fifthly, that the Governor General had not the power of making such contract without the authority of the Spanish government. All right, so that's this document. We got another one here, United States Congressional Serial, set volume 287. And also, as you guys can see, right, the contradictions never were fulfilled. The contract was revoked. Same info was right here. So even anybody claiming under Bastrop, just like Maison Rouge was, even his claim was not legit. We got reports of committees here, 16th Congress, first session, 49th Congress, same information, guys. And it goes on and on. This case was very well known. And what happened, what was determined was also very well known. So I hope you guys understood that claiming, trying to win a case or getting land using the Maison Rouge land grant is not really a good defense, because that was thrown out already. That was already thrown out. There was many court cases that were similar, and the United States made it very clear why the heirs of these supposed grants are not entitled to it.